You know, several years ago, I got asked to defend a 78-year-old pastor in an assault case. You see, my client went to sleep one night, and when he woke up, his neighbors had moved the fence dividing their property 2 feet over into his yard. And so he saw it and he realized, he said, hey, they moved the fence. And so he called the police. And of course, the police didn't believe him. And lo and behold, he decided one day to go and get a survey done. And his survey showed that the fence had been moved for 2 feet. He called the police again, but they still didn't believe him. And his neighbor eventually got a survey, and their survey showed that the fence was in its right place. So over time, not wanting to cause any trouble, the pastor just started to take care of that lawn. That little stretch of lawn, he'd mow it and he'd water it and he'd fertilize it and he'd take care of it like it was his own lawn, because it was his own lawn. But his neighbor kept getting frustrated and upset about him being on their lawn, and they called the police repeatedly. Back and forth they went. And one day the neighbor set out some water sprinklers, and the pastor, 78 years old, in the hot Houston sun, got behind that lawnmower and was pushing that lawnmower, cutting that strip of grass. And his neighbor turned on a water sprinkler, and they hosed him down like a dog. So much so that his cell phone that was in his pocket was destroyed by the water. Hey, confused, jarred, he picked up the water sprinkler, and his neighbor came out of the house charging towards him, yelling and screaming and charging towards him, angrily yelling and screaming at the pastor. And he's holding the water sprinkler, and his neighbor's yelling and screaming and charging at him fast. And he does what any 78-year-old pastor would do in that situation. He went upside his neighbor's head with that water sprinkler. And lo and behold, the police were called, and when the police got there, they believed the neighbor. They believed the neighbor that he was assaulted. And so here was a pastor charged with an assault case. And when I saw the case, they came into the office, I said, that sounds like self-defense. Clear and simple. He's afraid. He's fearful for his life. This guy's coming up with him, or this neighbor's coming up with him with this water sprinkler threatening him. And so we headed to trial, because pastor wasn't going to plead to anything. He was not guilty and wasn't going to plead to anything. And so we headed to trial. And I remember sitting at the table while the jury, the prospective jurors, were filing in, each one by one, and having my jury questionnaire and my chart, sitting down and writing down the names. And the pastor asked me, says, Eric, what's going on here? And I said, well, like I told you, pastor, this is what we call jury selection. We're about to select the jury. We get an opportunity to deselect the jury. There'll be some jurors that will disqualify themselves for cause, and there'll be some that we can strike for whatever reason we want to, and we can use what we call peremptory challenges. And the pastor said, Eric, the Holy Spirit told me we need to strike the first 6 people. And I said, well, Pastor, the Holy Spirit not telling that to me. And he said, the Holy Spirit says we need to strike the first 6 people. And I said, well, he can't be serious. The pastor just doesn't understand. I said, well, maybe we'll do the voir dire. Go through the voir dire, ask our questions, and we'll see. You know, maybe those 6 people will be terrible for us. Maybe they won't be good jurors, and we can just go ahead and strike them. Let's see what happens. So lo and behold, we do the jury selection, and it's a good voir dire, a very talkative panel. And the first 6 people are solid self-defense jurors. Solid self-defense jurors. They're the kind of jurors that are looking to shoot somebody. They're the kind of jurors that you want on your case in a self-defense claim. So I turned to the pastor and said, Pastor, man, we can't strike those first 6. Those first 6 people are solid. They're smiling at you, Pastor. You see them, they're looking over at the table smiling at you. When you got those kind of people, you need to keep them. The prosecutor's probably going to try to strike them. We can strike the other ones that aren't that good. And he tells me, the Holy Spirit has spoken. We need to strike the first 6 people. And there ain't no arguing, Eric. We need to strike the first 6 people. And that case is one that kind of pictures for me voir dire. Now I have up there, it's not just lagniappe, it's voir dire. And for those of you who are not from New Orleans, you might not know what lagniappe is. Lagniappe is just a little something extra, a little something extra. Voir dire, and especially in the self-defense case, is more than just a little something extra. I've seen people, lawyers, try cases, and during voir dire, they spend their time giving statements and giving talks about the Constitution, and the Constitution is important, don't get me wrong, but they spend their time giving speeches during voir dire, when voir dire is the opportunity to probe and find out who's going to make the decision about your client's life. And I felt in that case that we wasted it, that it was just a little something extra that we had. It wasn't the gift that we truly have in the pastor's case. And so I want to kind of talk to you a little bit about voir dire and how I do voir dire. Some of you may have said, and she didn't read it to you in the bio, but some of you I see that I know, I've recognized, who've been students at the Trial Lawyers College. I'm actually on the staff of the Trial Lawyers College. I've been there for 12 years. So the process that I use voir dire, some of it is taken from the Trial Lawyers College, what I learned from there. But what I'm going to talk about in terms of how to conduct the voir dire, it is not the Trial Lawyers College method. There are pieces of it, but some of it is what I've done over the years that I've found to be successful, and I want to share those with you. But I think voir dire is a very important part of trial. And in self-defense cases, as well as with other defenses, one of the things that we have to repeatedly combat is prejudices against defenses. Prejudices against defenses. And I tell you, we've got a lot of ammunition and a lot of reason why that's the case. I mean, everybody's familiar with O.J. Simpson, the O.J. Simpson trial, and the argument was an alleged police frame-up. After the O.J. Simpson trial, lawyers, everybody was saying, if it doesn't fit, you must acquit. That was a phrase that lawyers used in trial, but jurors didn't trust lawyers and didn't trust the process. They were upset at the defense, at raising of defenses. And recently, in Phil Spector's trial, his murder case where he argued that the complaining witness actually committed suicide, both those defenses, OJ's and Phil's, were defenses where they were saying, I didn't do it. This is the explanation as to what happened. But jurors rejected those defenses. They didn't reject OJ's, but jurors rejected Phil's defense because of their frustration. Now, Jodi Arias and other defenses are defenses where they're saying, I did it, but I was battered, I was beaten, I was bruised. I did it, but there's some explanation as to why I did it. And we all know Ethan Couch. Now, Ethan Couch set criminal defense lawyers back years. Years. If his lawyer's here in the room, raise your hand. We're good. I mean, I'm happy he was successful in getting this kid a probation by making the argument for affluenza, but jurors hate lawyers and hate defenses as a result of it. And James Holmes, who I think was insane, argued an insanity defense, and it was rejected by jurors because people have prejudices towards defenses. And I think, we even see it in self-defense cases that were successful, that people have prejudice against jurors. I mean, George Zimmerman, that case was one of those cases where Zimmerman's acquitted, but everybody's upset. And the mantra that people have is that you can't shoot anybody. You can't just go around shooting people and claiming self-defense. I mean, stand your ground laws. I feel threatened and I want to shoot someone. That's the heart of self-defense. But because of George Zimmerman and the feelings that people have, the prejudices they have towards defenses, it makes our job a little difficult. And in voir dire, we've got to deal with it and handle it. I think people see defenses as excuses. As excuses. Oh, you did it, but this. They look at the defense, which a person is justified in acting, as an excuse. I think nowhere better as a scene. I don't know if any of you are familiar with the Hockey Dad trial. That was in Minnesota. Thomas Hunter was a father of a kid who played on the hockey team. Another father on the same hockey team, they got into an argument, and during the course of the argument, Thomas Hunter beat him, and the guy died as a result of it. Now, Hunter was a large man, but the person he beat was a small man, and Hunter's defense was self-defense. And they plastered him in the media, and they plastered him in the cartoon, and I think this cartoon is so telling. It's so telling for me about self-defense. It captures the issue. And the issue is that our client has to be the rabbit. That our client has to be the rabbit. Our client has to be, it sounds so simple, but our client has to be the rabbit. I mean, we feel good about the rabbit, right? If the rabbit's using self-defense, we don't think it's an excuse. We feel good. We want to root for the rabbit who's engaged in self-defense. We feel like we can empathize with the rabbit. The rabbit who's been abused, the rabbit who has a story, the rabbit who has a narrative, we feel that we can empathize and get behind and support the rabbit. And I tell you, rabbits come in all shapes and sizes, right? Some rabbits are rabbits as a result of circumstances that occur that are the result of the case. Some are just the cards they've been dealt in life, but they're the rabbit. I mean, who feels bad about a disabled person who defends themselves from being abused? I mean, I don't see any hands. But all of us have represented disabled people. All of us have, if we're doing criminal defense work, we call them ill though. We call them mentally ill, not mentally disabled, we call them mentally ill, but the narrative has to change. They have to be the rabbits. A mentally disabled person, a person who is disabled, who can't quite function, a person who can't quite protect themselves because of bipolar disorder, not a mentally ill person. A mentally ill person is someone that's wrong, that's bad, that their illness, their disease is an illness. It's something that they've done to get. But a disabled person, that's just the cards they've been dealt. But they're rabbits. And rabbits come in all shapes and sizes. Some of them even have guns strapped to their waist, right? They encounter someone, he's just doing his job. He's just there doing his duty. His job as an officer. He gets up every morning to his wife, and his hope is to come home. So he encounters this person. Now, mindful, he's there with 4 other officers who also have guns strapped to their waist, but he encounters this person who might threaten his opportunity to get home. The narrative has to change. And we all like those rabbits. You know, I told you about the pastor and us striking those jurors. I didn't tell you how that case turned out. We actually did not get a self-defense instruction. We tried the self-defense case, but when it came time for the pastor to testify, the pastor said, "Oh, no." I said, "Well, pastor, your neighbor was coming towards you, aggressive, angry, charging towards you, right?" "Yeah." "You were afraid, right?" "Yeah." "And so you were afraid for your safety, true?" "True." "And you hit her with the water sprinkler." "Oh, no, Eric, I never hit a woman. I had never hit a woman. No, sirree, I didn't hit her with the water sprinkler." Now, she has bruises all across her face. The water sprinkler's broken on the side. But the pastor, based on his testimony, we didn't get a self-defense instruction. But the jury acquitted the pastor in like 2 or 3 minutes. Even though we didn't have a self-defense instruction. And the reason they acquitted the pastor was because he was the rabbit. He was the rabbit. He was the person they cared for. He was the person that they related to. He was the one they wanted to protect, the one they wanted to help. And I think in these cases, in voir dire, we've got to take that approach and change the narrative. Now, I want to talk to you a little bit more specifically about self-defense and some of the laws related to self-defense. I've kind of narrowed it down to issues that I think come up in every case involving self-defense. And there's some issues, and I want to kind of talk to you a little bit about how to voir dire on those things and kind of share with you my approach to voir diring in self-defense cases. Of course, I think the first thing is obviously knowing the relevant law and attacking it in midst head on. Knowing the relevant law and attacking myths head on. In other words, your jurisdiction, I'm not sure what jurisdictions you're from, and all of us are from different jurisdictions, and the law differs in each of our jurisdictions. There's some areas where it's the same, but you need to know all of the law in relation to self-defense in your jurisdiction. It goes without saying. And you need to attack the myths head on. And one myth is that force has to be proportionate. How many of you have heard prosecutors say you can't bring a gun to a fist fight? You've heard that, right? It is one of the biggest myths that's there. And what I see is that I see lawyers accept that myth. They don't challenge the myth head on. And I think a lot of the reasons why they don't challenge the myth head on is because they don't know the law. Because the force does not have to be proportionate. And in your voir dire, you've got to attack that myth and challenge that myth. Now, how many of you think that, what are you saying now? Who has pause from me saying that the force doesn't have to be proportionate? Good. Because if you think about it, if the force has to be proportionate, if you've got a 78-year-old woman who's walking down the street and a 22-year-old man who's strapping and much larger than her comes up to her and attacks her and she pulls out a pistol and shoots him, that means she's guilty of a homicide because she uses a gun in response to fists. And nobody would think that that would be right. Is there anybody here who thinks that that's okay for her to be charged with murder if she's protecting herself from a 23-year-old man? She's a 78-year-old woman who's infirm and she has a pistol and this guy attacks her and she uses the pistol. Is there anybody here who thinks that she has used, inappropriate force? No. And most jurors won't think that as well. But one of the myths that you see, and I see prosecutors doing it in voir dire every day, in every case I've tried nearly, the prosecutors have argued that the client is not justified in using self-defense because the force wasn't proportionate. And in Texas, we even have a definition that goes towards it. That defines deadly force is not just force that causes death, but force that can also cause serious bodily injury. And I've looked at a couple other states, and most states have the exact same definition, which in and of itself refutes the argument that the force has to be proportionate, because you can be faced with serious bodily injury and defend yourself resulting in death. All right, now self-defense is judged from the actor's standpoint. Huge issue to be raised in self-defense in voir dire cases. It has to be judged from the actor's standpoint, meaning the person who uses self-defense. And you see that, and I'm going to kind of cover that a little later on. No duty to retreat. Some states, the law requires a duty to retreat in self-defense. In most states, there is no longer a duty to retreat. In Texas, where I practice, there isn't a duty to retreat. A defendant doesn't have to run. Even if someone is attacking your client isn't required to run, even if that person breaks off the attack, or he can safely run and he can safely get away. He has no duty to retreat. It is a huge issue. It is an issue that most jurors cannot follow the law on. Most jurors have in their mind made up that if a defendant can get away safely without taking life, he should, and that they would reject self-defense on duty to retreat. It is an absolute issue that you have to voir dire on if your state requires that there not be a duty to retreat. It's one of those questions where you can get numerous cause challenges, because people will safely tell you that, hey, if a person can safely break off the attack or safely avoid using deadly force, the person should avoid using deadly force. And if he uses deadly force, knowing that he can avoid it, I'd find him guilty. Even though that's not the law. That's a clear and easy question to get cause challenges on, and it's one that you have to address head on. Apparent danger. You don't have to be right. Now, a person is able to defend themselves even if they aren't right. If they think somebody has a gun and the person doesn't have a gun and they use self-defense, they're justified if they're reasonable in thinking that the person had a gun. That's one that jurors have a problem with. Most jurors don't like that. So you can shoot somebody and the person not really ever have a gun. So that's got to be an issue that you voir dire on. It's one that you can kind of spend some time on as well. It's a state's burden to disprove self-defense beyond a reasonable doubt. It's a state's burden to disprove self-defense beyond a reasonable doubt. Is there anybody here who practices from Texas? If you're from Harris County, the pattern charges do not contain this instruction. Yep. Sounds strange, right? Because, I mean, it seems just we accept it because we know it, but most charges, not just in Harris County, I practice in other jurisdictions as well, most charges don't contain this instruction. It is not stated in the jury charges. And lawyers don't pay attention to it not being in the jury charge because it's stated kind of like twisted a little bit. They twist it up a little bit instead of plainly stating that it's the state's burden to disprove self-defense. So it is a crucial issue. Because prosecutors will argue that the defense has to show it's self-defense. They'll come in and tell jurors in voir dire that it's the defendant that has to show self-defense. He's got to show self-defense. He's got to come in and he's got to be able to support self-defense. And that's not the law. The law is simply that they've got to disprove self-defense beyond a reasonable doubt. The defendant doesn't even have to raise self-defense. Most lawyers fall back on the mantra that the defense only has to raise self-defense. The defendant doesn't have to raise self-defense. Your client doesn't have to testify to get an instruction on self-defense. If your client does testify and he says that it wasn't self-defense like the pastor, then you're not going to get an instruction. But if self-defense is raised from the evidence, it could be a situation where someone's charging towards someone else and witnesses can testify that someone's charging towards someone else and that person looked afraid or that person stumbled back and then fired. That would be enough to get self-defense. It can be raised from the evidence. And it's the state's burden after it's raised from the evidence to disprove it, not just disprove it, but to disprove it beyond a reasonable doubt. Even if it hadn't been established, if there's some reasonable doubt about self-defense, the jury must acquit. And the jury needs to be told that during voir dire and needs to be examined on that during voir dire. For example, a situation like that might look like, is there anybody here who would require the defendant to prove self-defense? That may be a simple question. Yes, you require it, and you engage the person and says, thank you, ma'am. You know, I think if somebody's coming in and they're making a defense, if he wants us to listen and go with him, then I think he needs to bring forth the evidence, right? That's the feeling we have. Right? And that's how I feel too. If someone is bringing forth a position, they need to support their position. Right? And if he doesn't support the position, I'm not going to go with it. Well, would it surprise you if our law was that it was actually the state's burden to disprove self-defense beyond a reasonable doubt? And would you have a problem if you had a reasonable doubt about self-defense acquitting the defendant? You know, you can kind of play with the different questions to get a cause challenge on that issue. And prior violence on the part of the decedent can be admitted. This is something that I think isn't done often as well. Any prior act on the part of a decedent can be admissible at trial, whether or not a defendant knows about it. In other words, if you got a defendant who has a prior violent conviction for aggravated robbery, and your client doesn't know about the prior conviction for aggravated robbery, if there's an issue as to who's the first aggressor, then it can be admitted. His violent propensity under 404 can be admitted to show that he was the first aggressor. Get this, if your client knows it, it's a given that it's admitted. But the issue really comes up if your client doesn't know about it. If your client doesn't know about it and there's an issue about that, who's the first aggressor, who's the one that started the violence, who's the one that started the scuffle, then any violent tendencies of the complainant, of the decedent, can be admitted for that purpose. Can you imagine voir direing on that? If you anticipate admitting evidence about someone's violent propensity, can you imagine at the very beginning of your case, at the very beginning, before the beginning of the trial, starting to voir dire and talk about someone's violent tendencies? You know, it could look like, now, you've heard the judge say that the defense has to be reasonable, and that the defense has to be reasonable based on someone's standpoint. Is there anybody here who, if they knew about a dog in the neighborhood, and they knew about a dog in the neighborhood who had bit a whole bunch of people, whenever you walk down that street, the dog would charge out and try to bite you. If you were in a neighborhood and you knew about a dog that had bit a whole bunch of people, would you go in that neighborhood without a stick? Is there anybody here who would go in that neighborhood without a stick if you knew that this dog had bit a whole bunch of people? If you knew about the violence of a person, someone had violence, would you encounter that person without being prepared? Would you wait for that person to pull a gun if they showed the gun? Would you wait for them to pull a gun before shooting them if you knew that person had been violent? And if there's some question, for us as a, would it help you as a juror if you knew that a person had violent tendencies in their background to decide whether or not a person was justified in self-defense and whether or not that person with the violent tendencies was the first aggressor? I mean, I think that's powerful evidence, powerful questions, and a powerful way to shift jurors. I normally do not approach voir dire with the mindset that you can indoctrinate jurors. I think oftentimes it's a mistake, but I think in self-defense cases, unlike others, you've got to do that. You've got to spend some time talking about the law because most jurors don't know the law in self-defense. You've got to challenge them with the law because a lot of jurors can't necessarily agree with the law. And expert testimony has the mental health cases that they can be admitted in cases, and domestic violence and mental disability cases, which is the point I put in this slide just to say that it's a crucial point to self-defense. Domestic violence cases in terms of the battered spouse syndrome, I tried one, the case she talked about where the woman shot her husband in the back of the head and in the back. I talked to an expert, a domestic violence expert who was nationally known and had a national reputation. And the first thing she told me, she says, Eric, people just don't win them. Women just don't win battered spouse cases. You know, jurors just don't resonate with them. And they find women convicted. It may help us in punishment. It may help her get less time, but people just don't win it. And I couldn't accept that. I just couldn't accept that. It just didn't sit well with me that I was supposed to abandon my client, who I really thought was a genuine McCoy in terms of a battered spouse. That I was supposed to abandon her, abandon the defense, and play for punishment. And I just couldn't do it. And we didn't do it. And so we put our expert on, and the expert actually gave great testimony as to the mental state. Her mental state at the time she was being faced with her husband. That even though he was shot in the back, she didn't know if he'd turn around. You know, he went to sleep, and when he got up, he still hit her. She didn't have any moment that was safe. Her mental state was as such that she felt that no moment was safe. Even when his back was to her, she didn't feel safe. She felt threatened, and it helped. And the jury believed it, and they ended up acquitting her as a result of it. And I think sometimes when you have experts that can go and testify as to the defendant's mental state, it can be a bonus in a self-defense case. And you've got to voir dire on it. You've got to spend time talking to the jury about expert testimony. You know, and you got to talk to them about, is there anybody here who's an expert? Anybody ever been qualified as an expert? Would an expert help you and assist you? If someone spent their life work studying women who've been abused in domestic violence cases, would it help you to understand how a domestic violence victim might respond in stressful situations? You know, you got to voir dire on that issue as well. All right. Now, the process of voir dire. First, know the relevant law, and I talked a little bit about some of the relevant law and some of the relevant issues associated with the law. And then second, examine your concerns about the case. We have to examine our concerns about the case. And then do a personal assessment about how you feel about the legal issues in the case, and then conduct multiple mini-bodies. Let me go back to this. Examine our concerns about the case. One of the questions I have from young lawyers, at my office now, I'm the division chief or the trial division chief, and I supervise lawyers in the PD's office in Harris County. I'm actually an assistant public defender. I work for the Harris County Public Defender's Office. And I've been doing that now for, I guess, five and a half years now. And one of the things that I do now is I supervise younger lawyers. And one of the questions I get from younger lawyers is, how do I figure out what to ask during voir dire? I've got this case, Eric, and it could be a PCS case, it could be a robbery case, it could be any type of case, and they'll say, how do I figure out which questions do I ask? Do you have any voir dire questions that you can give me? And I always say, no, I'm not going to give you any voir dire questions. You need to come up with them and develop them yourself that are case specific. And this is a method that'll help you develop questions for your case as case specific by examining your concerns about the case. For example, you may have a case like the one I told you about, the woman who shot her husband in the back, where an issue for you, one of your concerns is her shooting him in the back. She's saying self-defense, but she shot him in the back. How could she be in fear? How could she be in danger if it's her back? He's either running from her or leaving from her. So that's a concern. And why do I feel that way? Well, when I was growing up, I remember watching cowboy movies and only cowards shot somebody in the back. I mean, shooting somebody in the back was a negative thing. I'm examining my feelings, my concerns about the case, and examining my feelings, doing a personal assessment about how I feel about the legal issues in the case. I can't see that being justified, shooting them in the back. How can you be in danger if you shot somebody in the back? Is the feeling, right? And then what I always do in preparation for voir dire, that's how I develop questions. And so that becomes a question for me. You know, shooting in the back, a concern of mine is that he was shot in the back. And I'll go around doing multiple mini voir dires with lay people. I might see the postman and I say, hey man, what's going on, Mr. Postman? And he said, hey, Mr. Davis. I said, I want no certifieds. He said, no, you ain't got no certifieds. All right. Now I asked him, I said, I would ask you this question, bro. What do you think about the situation? I got the situation I'm dealing with. What do you think about a lady who shoots her husband in the back 2 times and then shoots him in the back of the head and then, then lies about it to the police multiple different times? He said, guilty, bro. She guilty. She guilty. And I said, okay, Mr. Postman, I hear you. I said, well, would it change your mind if you knew? And then I'd start talking to him about the different facts and different issues. And from the conversations I'd have, and I may be at a dinner party with my wife's friends, and I'll ask him a question. I'll say, what do you think about the situation? I got this lady who shot her husband in the back of the head. She followed him around with a pistol. She was trying to find him. She had called him on the cell phone, and he picked up the cell phone, and she heard giggling in the background and knew he was with another woman. And so she was upset at him, and so she followed him around looking for him with a pistol. And then she finally caught up with him and then shot him in the back of the head and shot him in the back. What do you think about that? And he said, guilty, man, guilty. And then I talked to him a little bit more. I said, well, would this change your mind? Would it change your mind if you knew that he had threatened her? Would it change your mind if you knew that at the time that she shot him in the back of the head and the back, that he had just told her that I'm going to whoop you, do such and such to you? Would that change your mind? And then, yeah, that changed my mind. And so from the conversations I might have, I said, well, what causes you some concern about that? He said, what causes me concern, man, is that I can't see how she's in danger if she's shooting him in the back. So from these conversations, these mini voir dires I'm having, these many discussions I'm having with people, I'm figuring out 2 things. 1, I'm figuring out how to talk to people about the issues. And 2, I'm figuring out issues that may be of concern to my jurors. And so I can figure out questions that I might want to ask and things I might want to tell them during voir dire. Sometimes I even do mock voir dires. I'll bring in secretaries, bring in people, and then after I've formulated the questions I want to ask and how I want to ask them, I'll bring in some people and then practice the questions. Go through and practice the questions during a mock voir dire. All right. And then, of course, you apply your concerns to the law and prepare to share them with the jury. And you share your concerns to the jury and then tell the jury the law that addresses your concerns. If you have the situation where someone's shot in the back, you might tell them, well, the law says that a person is reasonable in using deadly force if the person reasonably apprehends, meaning they reasonably think that they're in danger. They don't have to actually be in danger. Just if they reasonably think they're in danger, the law says that they can use self-defense and that they can defend themselves. And I might have that, and I may actually sit and talk to the jury about that and tell them, hey, look, I have a real big issue with the fact that there's an allegation that someone was shot in the back of the head and someone was shot in the back. And there's an issue about whether or not someone who's shot in the back was a threat or a danger. If a person's shot in the back, that means they're facing away. They may either be running, they may not be attacking anymore. They're moving away from the person. So I have a question about whether or not the person may have been in danger. That's an issue. That's a concern that I have. I said, but the law seems to suggest that a person just has to be reasonable and apprehended. Is there anyone who thinks that there's no way that you could reasonably be afraid if someone is facing away from you? And some people might raise their hands. Ms. Jones, thank you. Because I have that same feeling, Ms. Jones, that I don't know. I don't know if a person can be reasonably afraid. Would the history of the person make a difference to you? And mostly they'll say, yeah, that would make a history. If the person had an issue where they had been attacked by the person before, and if the person was relentless in attacking them, that even though their back was to them, they didn't think the person was afraid of them with the gun, would that make a difference to you? Yeah. And so different issues, you can kind of spend time applying a law to the concerns that you have and moving it forward. Use hypotheticals to illustrate the law in action. And I think I did that with the older woman. Explain that in terms of proportionality. If the force isn't equal, if you've got a situation where you've got an older lady and she's being attacked by a young man, then of course she would be allowed to utilize whatever force is necessary. And the force doesn't necessarily have to be proportionate. But even in situations where you might have a question or an issue with immediacy or force being immediately necessary. There was a lady who was outside. She was outside of her house, and she was working in the garden. Some of you may have heard this story. If you've heard the story, let me know. But she was working in the garden, and she was just tilling to the garden, and she hears the children scream. And they scream. And so she hears the screaming, and she hears the words, and the words are, sure, sure. And then she starts running in a direction, and it gets clearer and clearer, and it sounds like they're yelling, snake, snake. And so she gets close, doesn't see the snake, sees her kids yelling and screaming, but doesn't ever really see the snake, and then turns and runs top speed towards the garage and grabs a shovel. And she comes out the garage towards the shovel and it runs towards her kids, top speed, not even really looking in the area, but she just starts swinging in the area where her kids are. And then she starts swinging and swinging and hitting and hitting and hitting, and the snake dies. But she keeps hitting and hitting and hitting and hitting and hitting. So there's some question about my client shooting him multiple times after he died. He was a snake. Ladies and gentlemen, he was a snake. Is there anybody that has a problem with shooting or killing or hitting a snake multiple times, even if the snake has died? So sometimes we can use some hypotheticals to illustrate issues in the law. If a person thinks it's reasonably necessary, their fear may still be there, even though the person's dead. They know this person's a dangerous person. They may keep shooting as well. It may shoot 20 times or 10 times or 15 times. It may reload the clip and shoot some more. All right, and then use commitment questions to address issues of the law. Perfect. Commitment questions to address issues of the law. And I think we talked about that. Okay, shot in the back and immediately necessary. Any questions? Do I ever get stopped by the judge? Usually no. Might surprise you, right? But I don't usually get stopped by the judge. Except there was a case I tried, in terms of any voir dire I've done, I could say yes. But in self-defense, no. If I'm consistent on the law, most judges will let me voir dire on issues of the law, usually. And there have been other issues where I've been stopped by the judge for some, but on self-defense issues, no. Yes, sir? Yeah. Well, it's interesting that he would say it wasn't relevant. I mean, it's definitely relevant. I mean, I've been in cases where there's been some evidence that my client was a person who committed a crime, and the prosecutor had additional evidence that he was the person that committed the crime, and that was still relevant. You follow me? And in your situation, you may have, they may be agreeing, or at least saying that it's not in dispute, but the evidence is still relevant. I mean, that may be something you can argue to the judge. I don't know if your jurisdiction allows you to mandamus the judge. But that may be something to look into doing. I would be surprised. He made a pretrial ruling. It may give you an opportunity to mandamus to take him up on appeal. And I would probably still lay back and try to introduce it at trial at some point in time if they open the door, if there's some issue about the dispute or about who was the aggressor, if there's any question. If they come in conceding that he was the aggressor, I mean, that's good evidence for you anyway. But you may still be able to get that other evidence in as well. Okay? There was some other questions? Yes, sir? His question was, I talked a little bit about a client who had lied multiple times to the police and then had claimed self-defense. How do you get around an issue where you have a client who lies multiple different times and then is finally claiming self-defense? I might have to tell you a little bit about the case. That case was the same one actually. It was the one where the woman had shot her husband in the back of the head. She called her husband and, of course, he was with another woman. And so the evidence and testimony was that she got a gun and followed him around with a gun looking for him, wanting to confront him on that particular night. She goes home. She tells him to catch the bus home. He catches the bus home. She goes home and he's shot in the back and in the back of the head. That was the state's case and their argument. And when she's arrested after shooting him, she tells the police, he was coming at me and I shot him. And they ask her, they said, well, did you follow him around? Did you have the gun with you? She says, no, I picked the gun up off the coffee table. I didn't have the gun with me, is what she says. And then she says that I wasn't following him around. I wasn't looking for him. I was just driving and drinking. And then I was just upset. And then I got home and I shot him. That was pretty much how it kind of shook out a little bit, And then there was some added information. They asked her about her shooting at him a previous occasion, which she didn't say anything about. They asked her, did you ever had a dispute before? She said, no, we ain't never had no dispute before. She said that kind of stuff. And then we made an argument of self-defense. The issue really came down with her case was that the jury saw her as the rabbit. You follow me? I mean, the whole trial, we put on more witnesses than the state did. Yeah, she had some lies, and yeah, she had some issues, and we kind of dealt with it with an expert. We used a guy. There's a guy out of Texas. What's his name? If you remind me later, I'll look and see his name. But there's a guy who's a retired police officer who testifies on behalf of police officers who've been involved in shootings. And police officers who are involved in shootings, they forget a whole bunch of details. And his testimony is under the stress of the situation. Police officers aren't always able to remember all of the details that happen during shootings. So they leave out whole sections of what happened. And so we brought him on and had him testify about how her under the stress of the situation may have left out all the stuff about how she shot at him before and how she followed him around with the gun. We brought that witness to sort of combat that. Okay? All right. Any another question? Yes, sir? Good question. Depends on your jurisdiction. I'll say that. There's some law to suggest that it doesn't in Texas. There's some law to suggest that it doesn't. His question was, when you talk about the the complaining witness's prior bad acts, or at least prior violent bad acts, that you can open the door to the defendant's prior bad acts. And I said that was a good question. Because if your client has a whole bunch of, prior violent crimes, you might want to reevaluate or think twice about introducing the complaining witness's prior bad acts. In Texas, the defendant still would be able to sort of be shielded if he didn't testify. That wouldn't necessarily open the door in every case. In some, yes. It kind of depends on the situation. You follow me? If it's a situation where he knew about violent acts, and I'm not talking about like prior convictions of a complaining witness. I'm talking about violent stuff that they've done in the past. Like he may have beat somebody up around the corner, or he may have done something violent in the neighborhood. And if your client knows about the violent activities of the complaining witness, whether or not he has been convicted of it, whether or not there are even witnesses to it, if your client testifies, he can testify as to it. But that's all admissible. Prior acts, not convictions necessarily. Yes, sir.
If you had somebody, a client of color, does that affect your ability to think in terms of voir, or have you had to deal with that in voir dire with self-defense?
Give it to me one more time.
Sure. Client of color, and you're claiming self-defense. Is your voir dire any different in dealing with that?
Just last year in October, I tried a case that was in the newspapers in Houston, where my client was an African-American who had killed a Caucasian man. And the man was breaking into his truck, and the allegation was that my client beat him to death with a crowbar. And there was a ton of media, people were protesting, and they were saying the only reason he was charged was because he was black, that my client was black. And that the complaining witness, the only reason they really took this seriously was because the complaining witness was white. And I don't know if you guys ever heard of Joe Horn. Joe Horn, he's a defendant in Houston, a white guy in Houston who shot some black people who were breaking into his home in cold blood, basically. And I think his case wasn't even cognizable of the law, and he was no-billed by a grand jury. And prosecutors have still refused to touch it again. And so there was all the comparisons with our case to Joe Horn, and we tried that case, and we didn't talk about race. We had a debate about it. We went around and around about it, myself and co-counsel and our client, because I wanted to voir dire on race. And I knew how I would do it on race in this particular case. But the client was like, no, Ms. Davis, I think you're going to spook the jury. We done had enough talk about race already. It's been in the media. We had Quanell X, who's an activist in Houston. And then we had Derek X. We had all these different X's that would come in. He said, Mr. Davis, if we start talking about race, it's going to be a circus, and I might end up getting convicted. And I was like, well, sir, we need to talk about race. And he says, we don't need to talk about race, and I don't want you to talk about race. And so I honored the client. I understand that it's the lawyer's decision as to how to try the case, but this is my client, and I left race out of that issue. And he was acquitted of that murder case in October. You can look it up. There was some newspaper articles online about that case, and he was acquitted. And the reason he was acquitted was because he was the rabbit. He was the rabbit. And in closing the argument, I was able to tell the jury that my dad would have done the same thing. I was able to tell him that. And I think we looked at larger human issues. You know, it was a situation where the situation was he was out with his wife. He was a truck driver. He was going off on a load, and he and his wife went there, and someone was breaking into his truck. They were there in a truck. A guy comes out of his truck and is swinging a bar at him and his wife. He fights him, takes it away, and then beats him to death with the bar. So if I were out there with my wife, my argument in closing was, if my dad were out there with my mom, he would have done the same thing. There was a time when men would protect women. And so the issue of the trial became more than race. We argued issues that transcended race. I think sometimes, and this may be contrary to what you've heard earlier, I think sometimes discussion of race can hurt your client. Sometimes discussion of race can hurt your client. I'm gonna tell you this, I can't talk about race the way you talk about race. As a black man, I can't talk about race in trial the way that some of you who are not black can talk about race in trial. If I'm talking about race, I'm looked at as a race merchant, as a race pimp. If I talk about race, then I'm raising a race car, then I'm talking about race. So as a defense lawyer, I've got to be cognizant of how it might be received in my talking about race. So my talking about race is selective in cases. It is very selective in cases, and it's very subtle how I might do it in cases. Example, I'm representing a young black man who's accused of raping a white woman, right? Young black man accused of raping a white woman. My question of my raising race in that case might look like, this is something I don't really want to talk about. It's something that I don't feel comfortable talking about. And that's just the honest truth. I don't feel comfortable talking about it. But I think I've got to talk about it in this case. And the issue is one, and I'm hoping that the feelings that we have are not right. But my client's a young black man. And in this case, you might hear evidence that the complaining witness was not a young black woman, but was a white woman. And I'm fearful. I'm fearful and I'm hopeful, but I'm fearful of that fact. That fact makes me afraid. That fact makes me afraid for my client. Should I be afraid? Should I be afraid? And some jurors chimed in, yeah, you should be afraid. You should be afraid. I'd be afraid if I were you too. And we have a discussion. We start having a discussion about race. And our discussion about race, I would like to tell you that it led to cause challenges. And I'll say it didn't really lead to cause challenges. I didn't get anybody for cause. But he wasn't convicted. I'll tell you that. He wasn't convicted. He wasn't acquitted either, but he wasn't convicted. He had a hung jury. He had a hung jury, and the jury was hung 9-3 in favor of acquittal. And the 9 that were in favor of not guilty, one of them was white. Yeah. One of them was white. And, the rest were a mixture, Asian, Latino, and black. And the 3 guilties were all white. And so the discussion of race was necessary, I think, in that case. And sometimes the discussion of race is necessary, but I think how we approach it has to be done in a way of caution. Any other questions? I think I'm just about out of time.